room addition that complies with all the codes, you don't need to do that. But if you need some kind of special permit or special approval, the city has to send notice to neighbors within a certain distance. State law says 300 feet. City's code now actually says 500 feet and sometimes more, depending on the height of the building. But under a charter, again, the city would not be subject to those requirements. So they could reduce, and either this council or a future city council may or may not reduce the notice requirements to maybe 200 feet or 100 feet or, you know, who knows what. But the opportunity is there, yet in the future, the city could do something under the charter that it can't do now, which is to provide you less notice of a proposed development. Once the notice goes out, the city has a hearing and make a decision on the project. Under state law, for a variance, which would allow somebody to do something that code doesn't normally allow them to do, they're required to find that the variance is approved because of a special circumstance relating to that property. It's either smaller than normal, it has a slope on one side, some unusual characteristic the other properties don't have, and they need to, the idea would be that the city would grant a variance to allow some accommodation so that that property can build what everybody else in the area can, even though they have this unusual circumstance. That wouldn't apply to a charter city. So, again, the city could continue to do that, but they also could, at some point in the future, remove that requirement from the code and approve developments for other reasons. I'm getting a note here that I'm running out of time, so we'll just move a little quickly here as to what it won't change. There's been some reference to second residential units. Right now, they're under state law, there are certain conditions under which somebody can build a second unit on their single-family property. Those requirements apply to charter cities as well. So if a charter was adopted, that's not going to go away. Same thing happens with residential facilities for 6 or fewer in terms of alcohol and drug rehabilitation homes and treatment facilities, homes for the mentally ill, family daycare homes. Those are all considered by the state to be issues of statewide concern and could not be prohibited by a city charter. So those will continue to exist. Just real quickly, under state law, if we move now on public properties, the city could lease a piece of public property, a park or vacant land, for a period of 55 years. If they want to lease it to someone for 55 up to 99 years, they need to go through a certain process. It requires an ordinance, public hearing, et cetera, et cetera. Under a charter, some of those requirements would not apply. So the city could potentially lease property for up to 99 years without the residents getting the notice and the opportunity for hearing that they do currently under state law. So in conclusion, the charter won't immediately change anything, but it would create a situation where this council or a future council next year or 10 years from now could remove some of the protections that we currently have under state law, and that's the concern I think that we have. Thank you.
Thank you, Perry. You'll hear that theme throughout. It's not just what the charter says, it's what the charter doesn't say that gives us concerns too. Eleanor Regan. Eleanor, please.
I'm Eleanor Regan. I'm a retired attorney. I've worked first for a private litigation firm, and after 7 years I spent the entire rest of my legal career working for cities. First Costa Mesa, and then Culver City, and then I eventually worked for Anaheim and retired from there. Like Perry, I draw a PERS pension, which is not affected by the charter or anything that Costa Mesa might do or not do. That's vested. I'm going to say a few words about how the charter would affect or could affect elections. The provision of the charter that discusses elections says, quote, "Unless otherwise provided by ordinance hereafter enacted, all elections shall be held in accordance with the provisions of the Elections Code of the State of California and any other applicable law as may be amended or recodified for the holding of municipal elections so far as the same are not in conflict with this charter." At first reading, it sounds like it doesn't do anything, but think about it. A charter city has certain things that are uniquely municipal concerns, and municipal elections are one of those that's uniquely municipal concern. And so A charter city has total control over its municipal elections. The California Elections Code simply doesn't apply unless you make it apply. Well, the charter talks about it's going to apply, but listen to this. Unless otherwise provided by ordinance hereafter enacted. And everything else that follows is in a sense irrelevant, because what this charter does is empower the city council totally to have control over when and how elections are conducted. We don't know what this council or any future council will do. I don't want to attribute evil intent to anyone. But when you concentrate power in a few people, you run risks. So 3 people agreeing on the city council can change the date of an election from year to year. They can change the month, they can change the day of the month. They could put it on an inconvenient date, like the day after Thanksgiving if they want a low turnout, or have it coincide with a presidential election if they want a high turnout. The charter does not provide for any kind of public notice of when the election will be held. So you've got to find out for yourself. And how do you do that? You look up the municipal code. How many of you have done that? Go on, it's on the internet, and search for the election date for that particular election that's coming up, if you happen to know that it's coming up. If you don't know that it's coming up, you won't know to go and search and find out where it is. It empowers a city council to set the location of the polls wherever they think is best, and as many polling places as they think best. It could be, lots of them, which would be expensive, or if they want to save money, there can be very few. They could, for example, say, okay, everybody votes at City Hall, and you can count on waiting in a long, long line if enough people know about it. So my point is not that a charter is necessarily a bad thing. I've worked for charter cities, and the charter said when election day is. Culver City had theirs, if I recall correctly, on the first Tuesday in March. But this particular charter concentrates all the power, all the discretion in the city council, so that if 3 people agree, they have total control, and they can change it at will.